one-sided majority side in Parliament on Tuesday passed the controversial Electronic Transfer Levy Bill 2021. Meanwhile, the minority, which staged a walkout, has filed a stay of execution at the court with the hope of declaring the passage of the E-Levy unconstitutional.
Colleagues, the purpose of this bill that we've gone through really is to broaden the tax base of our country and to increase revenue mobilization domestically. I'm not too sure that any one of us in Parliament would disagree, minority and majority, would disagree that where we are as a country, we need to recline and look inwards to see if it's possible for us to increase revenue streams from within our own household, which is what the E-Levy seeks to do. The matters that should really confront us as members of Parliament is what we are going to apply the monies on. The bill provides that we are going to apply it to the development of physical infrastructure. That's number one. And I do know that almost every week, in particular on Fridays, questions are filed relating to the development of roads in various constituencies. Questions are filed relating to the construction of boreholes, delivery of potable water, extension of electricity to places hitherto unserved, construction of health facilities. And so we are not in disagreement. I'm not sure that any MP would disagree that we should apply this, the monies that would ensue from the E-Levy to the construction of physical infrastructure.
We are deeply committed and we are convinced that what Parliament is purported to have done, led by the majority caucus, with less than 137 members, only amount to a charade of approving a so-called E-Levy and subjecting it to second reading, consideration, procedural amendment, and third reading. And we are convinced that this Parliament, guided by the Supreme Court recent decision in Justice Abdullahi versus the Attorney General, the 1992 Constitution, which is the ground of our country, which is the source where all laws get their validity, the majority, following the walkout of the minority, did not constitute a voting quorum as required by Article 104 of the 1992 Constitution and the lucid judgment of the Supreme Court in the Justice Abdullahi matter. So for those of you who are doubting and want to know what guided the decision of the minority caucus, we simply walk out to disenable them from having, to quote the words of the Supreme Court, a voting quorum. They are simply and were simply less than 137. At least I'm using 137 because conspicuously everybody in the world in Ghana know the Honorable Adjoa Safo was not present, and therefore you had 137. Additionally, we know that there was an ambulance within the presence of Parliament, but the person who is purported to have been in the ambulance was not present in the chamber for purpose of exercising a vote. Therefore, every decision that they took with 136 flies as a sin against the ruling of the Supreme Court.